Apologies. Good afternoon, everyone. We'll get started in just a moment. I'm Professor Larry Helper. I'm the co-director of the Center for International and Comparative Law, and it's a great pleasure to welcome Professor Frank Upham, the Wilf Family Professor of Property Law Emeritus at NYU Law School. Professor Upham is an internationally recognized expert in a number of different fields, including property law, law and development, and the law of countries in East Asia and the developing world. He has many publications to his name, including Law and Social Change in Post-War Japan, which received a prize from Harvard University Press. He is also the founder and co-faculty director of the Global Public Service Law Project that brings activist lawyers from the developing world for an LLM in public service law to NYU, and he, I think in that capacity, is especially well suited to speak about the issues that he'll be talking about today: litigating for change, Valentine's Day, same-sex marriages cases in Japan in a historical, institutional, and comparative perspective. And with a comparative point in mind, before I ask you to join me and welcome Professor Upham, I want to just maybe situate these issues in a slightly broader context. I have shared with you, this is a map from Wikipedia. Normally I don't encourage my students to pull from Wikipedia, but in this case it worked and it gets updated all the time. You can see the world is very divided, regionally in particular, with respect to how to treat same-sex relationships and marriage equality, ranging all the way from same-sex intercourse being illegal and subject to the death penalty, through situations in which full marriage equality has been recognized. You can see that is primarily in Europe, the Americas, and also in the Asia-Pacific region, parts of the Asia-Pacific region. But this, I want to emphasize two things before turning things over to Professor Upham for his remarks. So first of all, this is an incredibly rapid set of changes in terms of the global regulation of this topic. The very first country to adopt marriage equality was the Netherlands in 2001. So we're talking 22 years, and we are seeing a remarkable change, not just in the Netherlands, not just in Europe, but really across the world, although unevenly distributed, to be sure. So that's one point to keep in mind, how fast things have changed. The second point is to talk about the ways in which courts have been involved in helping to push this change forward or retard or limit campaigns for marriage equality. So just two examples. Last month, the Panamanian Supreme Court handed down a decision that rejected a claim to marriage equality with respect to the interpretation of the Panamanian Constitution. That was a very surprising result, I would say, given that so many other countries, including courts in Central and South America, have recognized same-sex marriage following on decisions of the Inter-American Court and Commission of Human Rights, which have also provided a strong push for equality in this area. At the same time, in other parts of the world, these sorts of claims are ongoing and continuing. So in India, a few years ago, by court decision, decriminalized the colonial-era law proscribing same-sex consensual conduct. And tomorrow, the Indian Supreme Court is going to have a hearing on a petition asking for recognition of marriage equality. And I'm not well-versed enough to hazard a guess about how that case might turn out, but I do think that this global division of views, or the ferment that you see both for and against this kind of campaign, gives us the perfect opportunity to take a deep dive into the ways in which litigation for marriage equality is happening in Japan. And with that, I hope you will join me in welcoming Professor Uppen, who will give his remarks on that topic. So please.
Just in case any of you get in touch with my wife, you can tell her that I brought my blue blazer. I wore it in the property class that I just guest lectured in, but they're wearing it. I want to react initially to three things that Professor Helfer said. One is the speed of change. When I was a law student, I of course, the composition of the class was probably 95% male. There were, of course, gay students, but not as far as I knew. I was only vaguely aware of same-sex relationships. Now, I grew up in an extremely conservative environment, U.S. military, but of course, plenty of same-sex relationships there too. But so the rapidity of the change is just remarkable, and I think, and Professor Helfer can comment on this, but I think the most profound aspect of that is not the legal aspect. It's what I see as total acceptance. Now, I live in New York City, but I'm not from New York City. So it's just amazing to me. The second thing is the Panamanian Supreme Court decision, which I did not know about, and which is unfortunate in my opinion, because I am in favor of marriage equality. But it also has relevance to this talk, because one of the stereotypes of Japan is that it's very influenced by outside pressure. And the pressure so far has been to recognize same-sex marriage. Now, Panama is not, a full moon in the night sky of Japanese politics, but it may be just somebody turning on a light or, in the building window across the way. But it's interesting, and I'm sure I'll ask the lawyers that I'm in touch with about what they think of it. And then the third comment is how we should think of the at least two different possible ways to achieve marriage equality. One is through the political process, and the other is through judicial proclamation. Now, the latter seemed great until the Dodds decision. So, assume you all, that's a decision that overturned the right of American women to, depends on how you want to phrase it, I'll phrase it the politically correct way, to control their reproductive life. Okay? And we saw how tenuous that approach was. So those are, and I thank Professor Helfer for this, because these are all great backstops to what I'm going to say. I'm going to give some introductory notes, and then I'm just going to go down. I hope you all have this thing, and I'm making a few things about on this outline, and then I'm going to open it up questions. I was sitting in my office minding my own business, and I got emails from a couple of lawyers, Japanese lawyers that I knew from previous work that I've done, saying they wanted to come visit. And of course, I welcomed them, and they asked me if I would arrange to have a meeting with 5 or 6 lawyers, with me and with a colleague of mine. Sure. And they told me it was about marriage equality. I wasn't, it's not my field, but I wasn't aware of it being an issue in forefront of Japanese politics or legal politics, but I was aware of it. When they came, my colleague, who knows a lot about the American situation, said, thank you very much, I'm very flattered, and all the kuchiwa, all the popular stuff that you say when you're turning somebody down, but I'm not going to work on it. He knew about it. I couldn't turn it down because these were my friends, and they also were. I knew them because my field in Japan, in the study of Japanese law, has been basically social change mediated by the formal legal system, and not by legislation, although I've written about that too, specifically in terms of gender discrimination, but by lawyers. And lawyers in Japan are very different from lawyers in a place like Duke. I don't know what the statistics are at Duke, but the statistics for most law schools like Duke in the United States is that 80–90% of graduates go on to work for corporate law firms. They serve corporate America, which, is great. I live in a building, actually, it's a co-op, so it's not owned by a corporation. But, most of my life is controlled by corporations. I have nothing against them. I didn't take the course, but I got nothing against it. In Japan, most corporations until very recently had not a single lawyer employed. Their legal departments operated on the assumption that you can learn all the law you need to know, absent litigation, just by studying the law. You didn't have to become a lawyer. If you want to go to court, you've got to be a lawyer. But most corporations don't want to go to court. They'll do anything to stay out of court. So we'll see what happens with the Dominion lawsuit against Fox News. So the lawyers that exist in Japan are what I call, and my apologies to those of you who just heard this 59 minutes ago, Ippiki Okami, a lone wolf. Now they're in firms, 2 or 3 people. And these lawyers are the people who maybe some of you heard of the pollution problem in Japan. Post-war economic development, Japan experienced extraordinarily bad pollution. The Japanese thought it was the world's worst pollution ever. They weren't in the United States in the 19th century. They weren't in Britain in the 19th century. Everything is focused on where you are, and you think it's all unique. You ask Japanese, is Japan unique? Oh, absolutely. I think the United States is unique. Everybody thinks everything's unique. And then that's what comparative law should help us with. So when I decided to pursue a legal academic career, the pollution situation in Japan was horrible. And the political structure was not responding. And so a bunch of Ippikyo-kami, a bunch of Japanese lawyers, got together. They were already out of the establishment. They weren't, at Ropes and Gray or Arnold and Porter. And they brought suit. And to everyone's surprise, they won. And that transformed the Japanese environmental policy. Japanese environmental policy now is not an environmental lawyer or an environmental engineer, but I would suspect among the best in the world. And that was done by these lawyers. And I used to go to court with them. I used to go to struggle sessions, although in Japan they struggle a little bit more politely than they do in the mainland China, where I've also been to struggle sessions. So they came and asked me about this. And they asked my colleague. The colleague said, no, thank you. I couldn't say no, thank you. And also, I had just finished the book that Chertom mentioned about property. And I thought, okay, enough property for a while. And I'm looking for a topic. And I thought, this is a great topic. By this time, I was aware of gay rights, and I'd read Rausch's book about whatever gay marriage, why it's good for gays, good for America, good for your dachshund, good for marriage, everything. Which was very, very persuasive to me, but I understand it's a bit more controversial than I realized. So I was aware of the topic, and I thought, okay, this is a great topic. Okay, so that's why I took it up. It's also an excuse. Most people, including me, when they give a talk, say that they want the audience's help. Maybe on some level, sometimes some of them do, but mostly not. Because, if you're discussing things, if you're the presenter, you usually already know more. Now, it's a faculty seminar, it's a different issue. In this case, I mean it. So, I think you all have copies. You're welcome to the digital copy of this draft, and you're welcome to distribute it to anyone. And I'm not that concerned that people are going to immediately put it in the Sunday magazine of the New York Times. And anyway, having been a journalist, I know how little you get paid for that anyway. So, and when you distribute it, say, feel free to contact Upham if you have any reactions, because I need help. I don't know this field. Okay. There are three perspectives on the same-sex marriage movement that I think are worthy of thinking about, and they're taking as we look at it. And there are probably more. One is, as Professor Helfer pointed out, and I think this is correct, Japan is the only G7 country without some form of same-sex marriage. Now, why G7 is selected is probably because you couldn't say that about the OECD, or maybe you couldn't say it about NATO, so you choose G7 because it's a phrase that people know, and you can show that Japan is exceptional. And it is, I think, exceptional. I'm thinking about my next major project being gender discrimination in movable objects. Gender discrimination in affluent democracies. And the four countries that I have tentatively chosen are France, Korea, Taiwan, and the US. So I had to say democracy. I couldn't say countries because Taiwan's not a country, supposedly. And this is going to be part of it, but the only country that I think of which is in the situation like Japan, a rich democratic country that doesn't have same-sex marriage, and you can correct me, is Korea. South Korea. Maybe North Korea doesn't have it either, but that can be explained. I don't know whether it can be explained correctly, but the cliched explanation, and I come back to this because of course cliches like stereotypes are almost usually correct, almost always correct. It's just, you only use that term when we want to say they're not correct. Is the strong Christian minority in Korea. But there are other countries with strong Christian minorities. Some of you may live in one. In fact, you all are in one now. And that may not completely explain the Korean exception. But it's a simple explanation. And when you're looking at a whole world of a phenomenon, you're looking for simple explanations. But that's one of the things we can talk about. We can talk about Korea. But that doesn't explain Japan. I don't know why I became fascinated by Japan. I actually learned Chinese before I learned Japanese. But my wife learned Japanese, and she likes Japan. She doesn't like China. Probably because she doesn't speak the language. But Japan has always fascinated me, and I think the reason is that much as it drives me crazy when Japanese say, "Oh, Japan is a homogeneous country," I said, "Have you ever left Tokyo?" Or it's a homogeneous country. I mean, it's a conservative country. It's passive and so on. But there's a lot of truth to that. But I've made my academic career, as I think many American academics do, by challenging conventional wisdom, which is, again, almost always correct, and specifically challenging my mentors. So you make your chops in American academics by challenging the people who've helped you. It's a lot about our society. In Japan, you only challenge their wisdom after they're dead. People live a long time in Japan, but they eventually got. So I sort of attacked this. The guy I attacked this guy named Henderson, University of Washington, only person teaching about Japan in the United States when I started this. And so I started out trying to say, Japan's not so different from every place else, not so communitarian, and I use the environmental cases to show, and law is important, and there's conflict, and there's legal conflict. Despite that, and despite a subset of the activist lawyers that I know being gay, there's no popular movement. Same-sex marriage is 70% of Japanese society is in favor of legalizing same-sex marriage. Now there's an age distribution. People over 60 are 60-40 against, but everybody else is in favor. Why hasn't it happened? That's a political question. And one of the things that other people, well, not an explanation of that has been, an explanation of why there's no movement is that there's been no extreme violence against gay Japanese. There was, and Matthew Shepard comes to mind, although apparently there was a drug deal gone bad that was part of that as well. I don't, but anyway, but it symbolized homophobia and the brutality of homophobia and the inhumanity of homophobia. That hasn't happened in Japan. There's almost no overt homophobia. And I would say there's almost no homophobia. As if you ask people about, there was one incident, where a gay man was killed in Ueno Park. It's one of the homeless gathering places and same-sex relationship places in Japan. But again, like Matthew Shepard, it's very unclear that that was because of his homosexuality. So one question then becomes, is a virulent opposition necessary for mobilization? Do you need something that will make the gay population in Japan think, I'm in danger? And I don't know. Okay, so that's the status of LGBT individuals in Japan. And after that topic, I don't use T, because there's a statute and a process for gender transition in Japan. It's strenuous. You've got to go through a lot of processes. It has to be approved by a judge, but it's possible, and it's not a political issue. So we're really talking about LGBT. Yes. And one of the things that I think is interesting is, this is number 2. If you read Obergefell, it begins with the need for all people to express themselves. And to express themselves not only writing graffiti under some overpass, a lot of graffiti in LA, doing a lot of driving, and but there's sexual stuff. And to have that be not expressed as a hostile gesture or an antisocial gesture, I mean against the social consensus, but as part of the social consensus. And that's not what the complaints in these 5 lawsuits for marriage equality in Japan stress. They stress the pain. The way I put it here is individual freedom, and I say social inclusion, but really what I mean there is pain. They're just long complaints full of all of the things that gay couples cannot do. They can't get joint mortgages. Most Japanese don't have wills, and so it's very difficult for same-sex couples to get the surviving one, the decedent's assets. It's not a very good way to put it. Hospital visits, custody of children, huge practical problems that same-sex couples have in Japan that marriage would solve. But I think the most important one is the recognition. Well, another one I wrote as I was thinking about this is funerals. Funerals are important everywhere, and families control funerals, I think, everywhere. And if the family of a gay couple, the decedent, is hostile, doesn't want it to be recognized that the decedent was in a same-sex relationship, they can prevent the partner from coming. Incredibly painful. So, the next topic is why litigation. Japan, as I said, the cliche stereotype of Japan is that they don't sue. And I first understood the falsity of this, the substantial falsity of this, when I was a law student and I was representing, I was working for legal services, and I had a client who wanted a divorce. And this was Massachusetts in 1971 or 2 or something like that. And you had to have a judge proclamation of divorce. And the spouse, if the divorcee spouse had to agree, or it became a contested divorce and you had to go to court. And I realized then that the legal system had penetrated American society in an incredibly artificial way. Because you could go to court, and the judge always gave it. And I had this client, and I said to her, if you can't get your husband, then you've got to, and I didn't say this, I said, I didn't say, you've got to lie. I said, you have to say this. She said, but that's not true. Okay. But if you don't say this, you will not get a divorce. And the this was that her husband had deserted her. And he had come back one time, knocked on the door of the apartment, and she hadn't let him in. And desertion is a ground. Okay. So I kept saying it to her, you can't say that. And you will be asked by the judge. It wasn't. Sure enough, judge wanted to give her a divorce. He says, had your husband returned? Yes, he has. One time, I didn't let him in. Judge looked over at me, and and you could see, didn't you tell? So the judge says, counselor. I was a second-year law student. It's great, counselor. Comes up, and he says, you don't have grounds for divorce. And I said, I know. Then the clerk, not the clerk like you guys will be, but the clerk who runs the court, turned around and said, this was early December, Judge, it's almost Christmas. Divorce granted. So the point is that the court was involved then with American divorces. Well, not now, I don't think. But it still is in Japan. And it still is in You've got to register your marriage. And a local administrative organ won't accept it unless it's heterosexual. Okay. One way to change that, of course, is politics. And why politics won't work, we could discuss. Maybe some of you have a better idea than me. But the other way is litigation. And the cliche about Japanese courts is they're passive. And this is number 3. Some of you have heard of permanent employment, where someone joins a corporation in Japan and until they retire, they stay at the same company. Others may have heard that Japan has a very low divorce rate. It's rising now, but very low divorce rate in most of the post-war period. Japanese, uniformly, now there may be one or two who have read some article that I've written that might disagree, but 99.99% of Japanese will say this is Japanese culture. Another thing that I've been attacking all my life is that culture exists. Culture exists only when it is politically created. So after World War II, before World War II, there was a very high divorce rate, and there was no such thing as permanent employment. It was, people were laid off all the time, quit all the time. After World War II, both those social institutions, which are the structure of Japanese society, changing a little bit, still the structure, developed. Why? Because of judicial decisions. Because the Supreme Court refused to allow corporations to fire people unless the people had been, quote, disloyal. Stealing, but not coming to work, it's okay. And in Japan, in workplaces, the window seats, desks in open workplaces belong to what are called window people. They're people who would have been fired anywhere else. You just put them away where the activity is and they just sit there. They sit there for years until they retire. And I'm paid. So this was created by the courts. So I am not so pessimistic about the role of courts in same-sex marriage. But the difference is employment and divorce is another thing. Gender discrimination, another where courts have been extremely active in setting and creating social norms. They are able to do that through private law. To force a local registry to accept a marriage requires it being based on the Constitution. And Japanese courts, although they have been very interventionist in Japanese society, marriage, employment, they haven't been interventionist in the way, and I think more interventionist than American courts. They haven't been interventionist in the way American courts are. Arguing, say, to the Boston School District, you're not desegregating. I was involved in this. You're not desegregating fast enough. We're not just going to order another issue. Judge Garrity, I think it was Garrity, tried to clerk for him, but he said, I don't want someone to spend all that time in Asia. I'm taking it over. Took over the whole Boston school system. I think this is certainly, anyway, injunctive, intervening. But Japanese courts haven't done that. And so what the Japanese plaintiffs have done is they haven't asked the Japanese courts to order the Japanese government to recognize same-sex marriage. They have sued the Japanese government saying, your failure to recognize same-sex marriage is a tort, like your failure to control air pollution or noise pollution in an airport. You're violating same-sex couples' rights, just as you're violating someone's rights to quiet or clean air. And they're using something called the State Redress Act. It's the special act, civil procedure, to sue the state if somebody in a mail truck kills your dog. But they're saying the mail truck here is Japanese legislature, the Diet, not recognizing same-sex marriage. And the dog is the social exclusion of same-sex couples, which they say is a tort. There have been 3 cases decided. In order to win, the plaintiffs have to show that the Constitution requires same-sex marriage, that the requirement of the Constitution is clear, and that it has been clear for a long time. Okay. The courts have all said, three of them, the plaintiffs have lost in all three, but the plaintiffs have celebrated after two of them. Because of two of them, the courts have said, the Constitution requires same-sex marriage. There's no justification for treating same-sex couples differently from heterosexual couples. And that's the fundamental issue, a fundamental issue. But in order to win, they have to show that that unconstitutionality is clear. And one of the courts said, yes, it's clear. Another one said, yeah, it's clear, but not that clear. And then a third said, oh, it's not that clear, but it's getting clear, probably be clear in the future. But the common failing is that it's been clear for a long time. And they all go back and say, and for some reason they choose 1972 as the year, I don't know, that it became clear that same-sex relationships are natural, they're part of the human spectrum of behavior, they're not an illness, they're not a disorder, and that part is okay, but it's whether it's clear, and that's probably okay too, but it's how long. And so the courts have said, something like this, we're going to let the legislative process go forward, at least for a while. Now, there are two more district court opinions that haven't come down yet. Then, of course, there's the High Court opinion, and then it'll go to the Supreme Court. I don't know what the result will be, but I'll be interested in your comments. That's the end.
Wonderful. We definitely have time for questions, so yes.
I know you in the past have said that the Japanese judiciary is very independent and people view it as independent, far more so than the American court system in terms of its politics. Would doing same-sex marriage through litigation as opposed to a political route change that perception of the court system at all? Would it become viewed more politically?
Excellent question. Let me first say, I think the Japanese popular view of the courts is that they're not that they're independent in the sense of being honest, but they're not independent sort of as a political force attacking the superstructure of Japanese politics. Permanent employment created by the courts. Because the American occupation of Japan basically was made up of a bunch of New Deal liberals. They couldn't get everything they wanted through the New Deal in the United States, so they went to Japan where they could do literally, not quite, but almost literally, whatever they wanted. So all the liberal stuff that they wanted for the United States, they foisted on the Japanese. And one was non-fault divorce. So there are 5 grounds for divorce. The usual ones, adultery, drunkenness, and so on. And the last one in statute says any other reason that the marriage cannot continue. And the Supreme Court said, that can't mean that somebody who's culpable, namely having an affair, can get a divorce if their spouse doesn't want it. Can't mean that. So they just ignored that 5th ground. Then there's gender discrimination. Until recently, by my standards, but not by yours, if you got married, if you're a woman and you got married, you had to resign. And in the really liberal companies, if you had a child, you had to resign. And then Suzuki Satoko said, up yours. I'm not resigning. She got married. She said that to the company. And they fired her, and she sued. There was nothing in the Japanese civil code The only rule against gender discrimination was in wages for exactly the same job. Okay. Everything else was open to discrimination. It was done by everybody. The court said, we can't have this. The burden on Japanese women and Japanese families is too great. So you can't fire women just because they get married. So if you ask a Japanese, why do you have long-lasting marriages? Why do you have permanent employment? Why did Japan in 1985 and then later in the early 2000s pass statutes for gender equality in employment? They'll say, for the first two, culture. It's culture in the sense that it was politically politically created, as all culture is. For the last one, they'll say, oh, the Americans made us do it. And that's why the Panamanian decision. They're not going to say Panama made us do it, so it's not going to have an effect. But the U.S. is pressuring them. Professor Helfer will know this better than me, but I know nothing about international law. Didn't take that either. And there are international organizations that have pressured Japan to recognize in some way some same-sex relationships. And the Japanese haven't done it. And if they did do it, then I think Japanese would say this has been put a pressure on us. But the other things, which are equally fundamental, the Japanese think they just absorb it because the idea that the Japanese courts do not play a political role is deeply ingrained. Just like our view that our courts are very interventionist and deeply ingrained, I think our courts need a text. And if they don't have a text, they don't intervene. And if they have a text that says Y, they don't say X. Japanese courts do. Have. So, they're both national mythologies. Like every mythology, they're true, partially untrue, and extremely important to social structure.
So I'm trying to understand the big picture here, right? So you're describing this incredible story case that the Japanese judges are making decisions basically against the Japanese legislature, right? Legislature has not really enacted any law to regularize same-sex marriage, but the Japanese judges are doing that. So that's incredible, but also very puzzling, right? Because you said going back to a question about whether judges or Japanese judiciary are independent or not. I'm just wondering, how to think about it. What are their incentives? Right? You said there's no political movement, right? No gay rights movement, right? The legislature has not taken any action, and it's just why are they doing this? I guess that's my question, right? Yeah.
Okay.
I have another question.
That's, any of you familiar with the comfort women issue? Okay. Well, it's not as big a deal as I thought it was. Okay. Well, then never mind. I have a former student who was a big deal in the comfort women issue. Basically, he said that prostitutes for the Japanese military during the war had the best possible life, and they all chose to do it voluntarily. Most of the world thinks that's not true. But he argues that the Japanese courts are totally passive and conservative. He was my student, and he's a good friend of mine. We both like fast cars. And no one has responded to this. You know who this is, of course. He's never responded to my comments about permanent employment and gender discrimination. I think he says that the Japanese judges are all conservative. Well, they're certainly conservative in the same way that any bureaucracy, as I said, they mentioned I grew up in the military, so you go from military base to military base, and you live in quarters. But that's the Japanese judiciary. You're transferred around Japan. You live in government housing. I mean, there may be somebody from the equivalent of the FDA living next to you. They're not all judges, but sometimes they're actually. Your career is determined by judges who have become at the top. So how can they be doing these things? Well, one way they can be doing them is they do them invisibly. So they don't say, the Japanese government has to do this and that. They don't have to get reelected. They don't have to say, I'm for women's reproductive rights, vote for me. Or, I'm not for women's reproductive rights, vote for me. They just do it. And they do it in a subtle way. They refer to norms that are generally accepted, such as people need jobs. And women should not be divorceable by their husbands. And these cases, the divorce doctrines have changed as women have become more powerful and more economically independent. These cases came when women were totally dependent on their husbands, economically. So, and the judges, and so when the judges made these decisions, and when they made the gender employment decisions in the 80s and 90s, the popular opinion, I hate this term, but resonated, or the opinions resonated with popular opinion. I think that will be what will, in popular opinion in Japan about same-sex marriage is mainly Wu Sua Wei. No, I don't care. My wife, who also spent her career dealing with Japan, has her theory about this. Let me say that Japanese Tokyo University law faculty have about 100 people. Like faculties in the United States, there's 17 different categories of people. So exactly how you count the faculty. I've asked several members of that faculty, do you have any gay colleagues? Some have said, I don't know. Others have said no, and one has said one. There's one female now, too. An infinitesimal leap from 0 to 1. There used to be one before, but she left. And my wife's theory on this is that Japanese individuals, and this is kind of mega cultural theory that I don't like, but have a different sense of privacy. So when a good friend of mine was retiring from Tokyo University law faculty, he was the senior retiring person, or for some reason was chosen to sort of eulogize. Oh no, he wasn't retiring, but he was going to be the next year. So he was going to eulogize, or say goodbye to all the people who were retiring. He first didn't know who they were. He didn't know anything about them personally. He didn't even know, although it's almost invariably the case that they had gone, whether they had gone, they'd all gone to Tokyo University, of course. But he didn't know any of the facts about them. So the first thing he had to do was find out about these people. NYU's got a large faculty. I'm retired and I'm, almost 80. So you can imagine how deeply entrenched I am with the movers and shakers of NYU. But even when I was, I could tell you a lot about. I could tell you who was divorced, who was gay, who had children, whose child was arrested for drunken driving in Columbia County. I could tell you all this stuff. But not in Japan. And I think, this is my wife's name is Leslie. She said Japanese don't, on the one hand, it's a communitarian society, and we're an individualist society, but there's a real according to her, and I think she's probably right, there's a real sense of self that is not going to be communicated to other people. One of the times when I lived in Japan by myself, I was living with a prominent lawyer, and I would get phone calls. And the phone call would say, Ono sensei, irashaimashita. No, and they'd say, and this was in Japanese, if we would talk for a little bit, and I'd say, I don't know where Ono sensei is, and then they'd say, Homo desu ka? Are you Japanese?
いや、なんか日本語通じるんですけど。
Well, homo, I answered and said, well, actually, no, this is not my home. My home is America. And then they finally had what they meant was homosexual. And I said, no, actually, I'm not homosexual. That's how I found out that Ono Sensei was homosexual. I live with him. And, why would he tell me? I think an American would. And then, of course, when I discussed it with Ono Sensei, which of course I did not do, so I think that kind of, and it's hard for me to say that cultural perspective is clearly false. I think it's probably...
I just want to, because we only just have a few minutes left,
Yeah.
but just very briefly, trying to follow up on the point about the courts, because there seems to be a little bit of disconnect between the earlier cases that you spoke about in terms of the wrongful discharge and gender discrimination, where the courts seem to somehow magically have their finger on the pulse of society. So when they gave a categorical ruling, it seems to have been accepted. But in the same-sex marriage cases, that may be the way the applicants have framed the claim, they have had the courts go so far as to say, yes, this is a constitutional right, and yes, it is becoming settled. So that's a very standard move in many countries in the world for courts that want to signal to the legislature, go ahead, or to society, you really need to do something about this, because at some point we are going to intervene. And if you prefer us not to, then please get ahead of us. That's a very different judicial posture than what you described in the earlier cases. So I guess I'm trying to figure out whether that posture is one that is, there's so many questions I could ask about it, but one is, am I reading the same-sex marriage cases the right way? Are the judges trying to send a signal that we will do this, but maybe not for 10 or 15 years? Or are they really just going through the elements of the test that you talked about, and they're really coming up with their own independent assessment? They don't really care what message they're sending, to the extent.
Well, until your very last phrases, I was going to say they were doing, they were trying to expressing an evolving consensus and saying to the legislature, once those people over 60 are gone, we're going to decide that you've got to do it. But that is, it's not anthropomorphizing because the judges are human beings, but it's giving them an intent.
Mm-hmm.
And Japanese judges one of the things that still amazes me is when American Supreme Court judges go off and give political speeches. I think, how could that happen? But of course, Japanese state court judges are politicians, so they don't make many speeches. I have in my very big list of items of stuff to put in a revision of this paper, a Japanese judge favors same-sex marriage. And I remember seeing that some Japanese judge in some setting like this made some comment saying that he thought it should be recognized. But the reason I have that there is because it's so rare. And Japanese judges also don't leave the judiciary until they retire, usually. It's changing. And the judiciary is also bringing in more people laterally. So this is changing, but it's still, compared to the US, it's opaque. I don't know of a single memoir by a judge.
Well, I think we're going to have to leave it there, but thank you. Please join me in thanking Professor Upham for a really interesting and engaging.
And remember,